And if we'd start off by joining me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And if anybody is going to give testimony today, if you just stay standing and raise your right hand. Anybody giving testimony? You raise your right hand. Do you swear or affirm the testimony you give us the truth, the whole truth, and nothing but the truth? Thank you. By way of introduction, my name is Drew Smith. I am the hearing officer for the City of St. Cloud. I'm not an employee of the city. I am not an attorney for the city. I am a private practice attorney, but my role in these proceedings is to be an independent trier of fact. The order of each case, the city, both the speed program cases as well as the code enforcement cases, the city will go first. They will present to me the evidence and testimony that supports their case. When they're done, the respondent may come to the podium. If you have questions for the city's witnesses, let me know, and you have the opportunity to cross-examine them. If you do not have cross-examination, we can go straight to your direct testimony, and you can tell me anything you'd like me to hear about your case. If you have documentary evidence, you're welcome to submit that. Just understand that anything you submit, I have to keep for the record, so make sure you give me a copy. With that said, and I know that the police department notified the clerk that the first two cases today are not going to be heard, but I'm actually going to have her call them just so that we can get on the record that they're not being heard. So if you would, clerk, if you would call that first case.
Notice 24411, Jonathan E. Sarah, petitioner. Notice 27273, Harry James Delpret, petitioner. Notice 3.
Well, hang on a second.
Okay.
Just if I could, Mr. Smith, Dan Manzara, City Attorney for the City of St. Cloud, just to update you a little bit on the agenda tonight or today. There is a respondent here, Ms. Ibarra, for one of the speed zone cases. And then we have individuals here for case 2025-130 JRFM Enterprise, and then 2025-272 AMSAE Properties. So if you could, we'd like to take those cases first.
Take them in that order, 1, 2, 3, starting with Ibarra, then JRFM, and then AMSA is number 3.
That's right. Thank you.
Notice 30822, Natalie E. Ibarra, petitioner.
And of course, this is a speed zone violation case, and the police department, is it Corporal College, is going to present to you on this case, Mr. Smith.
Okay, thank you.
Hi, good afternoon. Sergeant Colley, St. Cloud Police Department, assigned to our traffic division. I'll go through my spiel and then I will show you the evidence we led us to hear. On August 28, 2025, approximately 16:09 hours, a 2016 BMW SUV bearing a Texas tag of Sierra Yankee Charlie 6091 was traveling northbound on Michigan Avenue, approaching Michigan Avenue Elementary. The vehicle entered the school safety zone and was captured on camera and LiDAR, traveling 27 miles an hour in a posted 15-mile-an-hour zone. The incident was then forwarded to the police department for review. On September 5th of 2025, Investigator Moncayo reviewed the evidence and he found probable cause to believe that the vehicle was in violation of St. Cloud City Ordinance 2024-48. A notice of approval was approved, and then it was mailed to the respondent. On 11/17/2025, a couple days ago, Officer Moncayo, he is out sick at the time, so I reviewed all of the information and I agreed with everything that he found, and I support that there was a violation for the BMW that he initially issued the speeding notice violation for. So I'll kind of go through and show you the evidence that led us to get here today. So this notice of violation that was sent to the respondent, and the next one's going to zoom in a little bit more so you can actually see the vehicle information on there. There we go. So it has the date, time, location, and also the vehicle description along with the tag in itself, and the date that it was approved is in the bottom right-hand corner. As the vehicle is approaching the school safety zone, it does pass a sign that says that it is, the speed limit is in photo enforced, and it does give the times on there showing that when it's being enforced. The vehicle then continues into the school safety zone. This one here passes the 15-mile-an-hour flashing beacon. On the top of the page, you'll have the posted 27 mile per hour speed zone. I'm sorry, 27 mile an hour that it was going, and the 15 mile an hour speed limit. Vehicle continues on through, just progresses through. A close-up of the tag so you can verify that it does match what is on the notice of violation. And then there is a video of it showing that the light is flashing and the vehicle progressing through the school safety zone. This is the camera log. It shows that when the camera did a self-test, it did it prior and after that the violation was captured, both of them on the same day. There is a radar calibration certificate showing that it has been calibrated within the last year of the violation. And the serial number on here matches the one that is listed on the citation. This is the administrative hearing letter that the respondent requested a hearing today. Maybe. There we go. And the staff recommendation is, based on the testimony and evidence presented in this case, is determined that the petitioner or the authorized individual was the owner, or correction, the operator of a 2016 BMW with the Texas registration of Sierra Yankee Charlie 6091. Was driving 27 miles an hour in a 15 mile an hour school safety zone. And this is a violation of the City of St. Cloud City Ordinance 2024/48. In addition to the original cost, there is a cost affidavit that goes along with it, preparing the case for everything. It would be an additional $89.49 as well. And that concludes the presentations. If you have any questions, I'm here.
And the citation amount as written was $100, correct?
That is the original citation amount. I believe that there is an additional $50 charge that goes on there for someone who responds to this, and if they are found guilty, we would request that the $50 goes away and that be replaced with the $89.49.
Okay, so you're seeking today $189.49.
Correct.
Okay. Ms. Ibarra? Ms. Ibarra? Not you? Is she present? Then I have some questions for you, Dan, and how the city wants to proceed. So before the meeting commenced, the clerk advised me that there has been a non-delivery on the change of address notice that was sent to Ms. Ibarra. So that gives me some reluctance to proceed, since if we move the hearing and she's not here, and if we have a certified mail that came back.
And Mr. Smith, I agree with you. I apologize. I misunderstood who was present for here. We were aware of that, and we assumed as we started out that of the 3 cases, there was one respondent here. So we were okay with this being rolled over to the next meeting, and we can deal with it then.
Then I'll take that as a motion to continue.
Yes, sir.
That motion is granted.
All right. Thank you. Appreciate you pointing that out. I apologize for the confusion.
Not a problem. It happens.
All right. And since I'm up here, I just wanted to also point out something that I missed. The case number 2025-243 on the agenda, Jordan, I guess that's Jordan Anthony. That case is being null pros by the city.
Okay. Got it. Thank you.
So,
Case number 2025-130, JRFM Enterprise LLC, owner, location of violation 1508 Illinois Avenue, St. Cloud, Florida.
and I believe the respondent is present for this case? All right. Okay, great. I just want to make sure. And the city is obviously ready to proceed on this case, and this is a violation of the city's land development code, section 2.2.7 and 10-3, related to work being done without required permits. And the code officer?
Good afternoon. Alex Miller, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: copy of the observation notice, copy of the courtesy notice sent by regular mail, copy of the notice of violation sent by certified mail, copies of the statements of violation and notice of hearing sent by certified mail posted at the property and City Hall, copy of the PowerPoint presentation, affidavit or posting, evidence of mailing, copy of the code sections of violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $438.79. On February 20th, 2025, Code Enforcement received a complaint that work was being performed at this property without the required permits. Upon arrival, I verified that new windows and doors had been installed and some interior renovations were in progress. I attempted to contact the property owner, but I was unsuccessful. An observation notice was left with the worker on site explaining the violations, and a copy was mailed to the owner by regular mail, and 3 photos were taken.
Officer Miller, if you would just narrate a little bit, what am I looking at? What is it that you want me to see in these photographs?
That is a brand-new door installed in front of the house, and new windows.
Can you go back to the door?
Yes, sir.
Oh, I see it. There is a door in that it's dark, and I was
Yes.
seeing no door, but now I
Yeah,
see it. Now I
it
see
is
the door.
dark,
Okay,
yes, sir.
thank you.
On February 18, a reinspection was conducted and I confirmed that the property was still in violation. A courtesy notice was sent via regular mail. On February 28th, while working on another case, I received information from a previous tenant indicating that the new owner was converting the garage into an apartment. The garage door had been removed, and the window on the side of the garage had been replaced with a door. I contacted the workers and advised them that a red tag had been placed on the property and no further work was allowed until the required permits were obtained and none photos were taken. This is they removed the window and replaced it with the door. The work that was going on inside of the garage. You can see the garage door when the property was bought, at the arrow. And this is when they removed and replaced, and there's no longer a door. Here's the red tag that was placed at the property. On March 4th, I verified that the property was still in violation. A notice of violation was sent to the owner via certified mail. On May 1st and July 3rd, the property was posted with a statement of violation and notice of hearing. However, I was advised to place the case on hold to allow the owner to obtain the necessary permits, and 2 photos were taken of the posting. On October 31st, after several emails and phone calls with the owner and no progress towards compliance, a reinspection was conducted. It was verified that the permit application was still in disapproved status and had not been obtained, and the property remained in violation. A statement of violation and notice of hearing was mailed via certified mail, and notices were posted at the property and City Hall. An affidavit of posting was created, and 1 photo of the posting was taken. I have also provided additional information in the folder with the permit reviews and the permit application. Nothing has been done since August. On November 14, and today, I verified the permits have not been obtained and the property remained in violation. It is the city's recommendation that the respondent be found in violation of allowing repairs and alterations to be performed prior to obtaining the required permits by the specified deadline. The city recommends that the respondent be given until December 12, 2025 to obtain the necessary permits or remove all unpermitted work. If compliance is not achieved by the date, a fine of $250 per day should be assessed until compliance is met. The city also requests that the cost incurred in bringing this case before the magistrate in the amount of $438.79 be paid within 7 days of the written order by the special magistrate, and this concludes my presentation.
Have permits been applied for?
Yes, sir. I provided with that information in the folder.
Is there an issue with what's been applied for?
They require more additional information, and nothing has been submitted since August.
Okay. Okay. Thank you. Respondent? Come on. And if you'd start by stating your name and your relationship to the property for me.
My name is Jose Rodriguez. I'm one of the owners on the property. So I guess in response, we have permits for the doors and the windows. Those were approved and they're on the property. I'm not sure why they're not showing, but I have a copy of them that were for the windows and the doors.
When you say you have permits for the windows and the doors, what do you mean by
Like they were
permits
approved-
issued by the city
Correct, yes,
for
sir.
the installation?
Correct.
Okay.
So those were approved, and then later on, then we were stopped for the other work that was being done. I immediately hired a company to get the plans and the permits, and unfortunately, the company that I've hired has just been really they're just non-compliant. I've been emailing back with the code enforcer and sending her the emails and showing, so I've been kind of held hostage. That's why it's taken so long to get them, but I did get a notice, an email just last week saying that they had resubmitted the plans with the proper information that was missing, and so I'm waiting on that. I mean, really, that's the only reason why it's taken so long to get this, corrected and rectified. It's not that I'm trying to be defiant or anything like that, but unfortunately, I made the mistake of hiring this company that basically hasn't been responsive. I paid them the money, and I don't have any more money to keep dishing out and hiring someone else to do plans and permits. So they keep telling me that they're working on it, but it's been, I understand completely. It's been a long, long time to get this taken care of.
Okay. So the city has requested December 12th for permits in hand. If I could just take 2 steps aside, I'm going to bring you back to the podium, but I'm going to ask the code enforcement officer a question.
Okay.
Officer Miller, did I misunderstand? So do you have record of there being permits issued for the windows and doors? Did I miss that?
Yes, sir, but the permits for the windows and the door have actually expired. So he had not come and had done any inspections, so the permits had expired.
I understand.
And after he was cited for the permit for the windows and the door, he was advised if he was going to do any additional work, he will need to obtain permits first, and he could proceed to remodel the garage without permitting first.
And I don't know, so this is a question, I don't know if you will know the answer to this, or if anybody in the room might. When he comes in, or as the company he's hired works through the permitting issues, can they reopen the window and door permit at the same
Yes.
time that so they can roll that into
They-
this new permit, the reopening into the new permit?
They could, but it would just be as easy just for them
Just
to
to
get an
reopen.
extension on the permit for the windows and the doors, the contractor
Okay,
can.
so they are still in the place where they can get an
Yeah.
extension,
Yes, sir.
they don't have to do a full new permit to get
Correct.
those? Okay,
Yes, sir.
okay, that's why, sir, you can come back up.
If I may.
Yes,
I
sir.
think there's a little bit of confusion because initially when we started the work, the code enforcer came out back in February and she fined us for the windows and the doors. There was no other work that had been done or that she had mentioned. So yes, we did continue working forward, but we didn't see the issue with it. Then she visited back and then she saw other work and then she said, wait, hold on a second, you guys need to stop. And at that time, that's when the red tag was put on the window, and we were told that I needed to get proper permitting and architectural drawings.
The reason that it wasn't that I was making matters worse for you. I wanted to understand, where the discrepancy may be, and just for your understanding, make sure that the company you're working with, make sure the company that you're working with understands they need to be making sure that the window and door permits are active, because building permits have a lifespan. And if there are no inspections performed within that lifespan, the permit will expire. And that's what they're testifying to me today, is that the permits are actually in an expired state.
So if I may ask a question. So we had got the doors and the windows installed and we had the permits. Should I have then called and had someone come out and say, hey, look, this has been done?
If those had been inspected, regardless of the result of that inspection, if the inspection had performed, that would have triggered an automatic extension of that permit. So
I see.
So, but that's what I'm hearing is that, yes, you had permits issued, but they're in an expired state. And
Understood.
it sounds like there's, depending on how long they've been expired, it can be easier or harder. It sounds like you're in the easier group where it's just reopening it and not
Okay.
having to submit application again, which would be much harder. So
Mm-hmm.
just make sure the company you're working with understands that they need to get those window and door permits also reactivated.
Extended so that we can basically close everything at
Yes,
one
sir,
time?
exactly right. That way you can do exactly that and just close everything out, have one final inspection. If it goes well, everything gets closed out all at once.
Understand.
I'm a little bit reluctant, especially this time of year. We're coming into Thanksgiving, December 12th, and it sounds like there's a fair amount of work to do. So I'm inclined to extend that out for another month and go to, well, it doesn't help me, it goes to 25.
Oh, for January?
To January. You have 60 days here, though. January 19th to 60th.
Yeah.
You actually, even the calendar didn't go that far.
Yes.
You wrote them out. So I'm going to extend that out to January 19th for the compliance date, just in case there's any wrinkles, and to get you to the holidays. Yes, sir.
I have a question. Does that mean that I have to have, does the work have to be completed, or we have to at least have the allowed permits that allow us to finish?
The request that's been made to me is permits in hand.
Okay.
So that means that the permits have been issued by the city. Any notes that have been issued, any revisions, anything that you need to come up with more information, that process needs to have been completed by January 19th.
Okay.
And you or whoever it is that's responsible for picking up those permits needs to have come in and paid for them. Because one thing I see some places is permits will be issued, but then they won't come and picked up. You have not obtained a permit until it has been paid for and picked up. So those are the things that have to happen by January 19th.
Were the windows and the door permits paid for? Because I know I paid them money for it, but,
Yes, you just have to get an
okay, I just need an extension, okay,
the licensed contractor has to do it.
okay. They have to come in and do it, and I can't pay for it, okay, understood.
Corporate ownership, it will have to be, yes, sir, it'll have to be the contractor.
I understand.
Mr. Manzares?
And thank you, Mr. Smith. I just wanted, so we're talking about compliance, I want to make sure he clearly understands. If you do get the permit by the compliance date that they've set for January of 2026, that permit has to remain active. It can't expire.
Again, so
So
is
you
there, do they say on there, like, you have
you-
30 days to?
You're going to work with a contractor?
Correct.
Your contractor should be well aware of that
Okay.
And be able to do that. So
Okay.
just make
And
sure.
And is it possible to get another extension as well if the
You
work
have to
doesn't-
talk to that would be
Have to come in.
that would be a building department issue related to the permit once the permit is issued, but for right
Do
now.
they give an allotted time that the work needs to be performed, or?
The permit will state all of that on its face, I believe, but until the permit's issued, I think it's 6 months. I think it's 6 months of those permits, the initial lifespan,
Total
right?
of 180 days, a typical permit, it's 180 days, and just to clarify, as my understanding it will continue if there is at least one final approved inspection. So you have to get an approved inspection related to the permitted work, and then it will continue and deal with that. And your contractor should be well aware of that.
So the city has also, part of their request, as to the first part, I'll go ahead and start working through my ruling. As the first part, I am going to order that there is a violation. Based on the evidence testimony presented to me, I do find that there is a violation. We'll order that the violation to be cured by respondent obtaining the necessary permits by January 19th, 2026. If not brought into compliance by that date, a fine of $250 a day will run from that point forward. So very important to comply with that date. If you have any difficulties, let code enforcement know early so they can work with you to help resolve those issues.
And do I continue to speak with the current lady that's been doing, or this code enforcer?
We can work with her, but you'll have to go to the building department to get the permit.
But he's saying if I have any issues, I can.
Just to keep code enforcement in the loop is what I meant by that, yes. Not that they can fix the issues for you, but just let them know that you're working, because that will be relevant to me if we're back here again, how hard you were working to get it done on time.
All right, and Mr. Smith, I apologize, there's been a lot of other discussion,
Sure.
but did you address the fine administrative costs that we?
About to get there.
Oh, thank you.
And where I am leaning on that and what I intend to do is, again, I want the money spent right now on getting to compliance, so I am going to order the administrative costs, because otherwise the taxpayers have to pay for it. Order the administrative costs paid, but I'm going to tie that, instead of the 7 days requested, which is what I typically do, but due to the amount and everything going on, I'm going to extend that out to January 19th, 2026 also, so that you can make sure you get those contracts pulled first.
Is that the 400 and something?
Yes, sir, it is.
Okay.
And everything I'm ruling today, the verbal, it will be condensed down into a written order that you will get in the mail. So everything I'm saying today, you'll have a document that you can go and refer to if you have any questions afterwards,
thank
need
you
to
very
refresh your memory. Okay. And that's all I have. Did you have any other questions for me before we close up this case?
No, you've pretty much hit them all, and so I need to get this code of the permits taken.
Stay on top of that company.
Okay.
And if they can't get it done, find another one.
Okay, thank you very much.
And actually, what I would recommend, when you get this order from me in the mail, make a copy of it, email a copy, send it to them and say, you guys have to stay on top of this or it's my pocketbook that's gonna get hit.
Is there anywhere that I can are they like Department of, like, for realtors, the BBPR, is there anywhere that I can go and relate this?
Is it the board of, and I don't know if this is something that would fall into that realm, but there is a board of, and I forget what it's called for the construction industry in Florida.
Industry licensing.
Yes, sir.
It's through DBPR.
Yeah, so here's, and again, I don't mean to elaborate, but I did go there because I also do real estate, and so I looked up the license, and the gentleman is deceased. So I don't
That
know
you
if
were working with?
Well, at least the person that holds the GC license, I don't know if maybe that's why it's taken so long for them to comply and help me through this.
Very well be the case, and you might need to start looking for another company to work with.
Okay, all right. Thank you very much.
Yes, sir.
Case number 2025-272, AMSAE Properties LLC, owner, location of violation, 606 Pennsylvania Avenue, St. Cloud, Florida.
Again, Mr. Smith, this is another violation case with regard to work being done without required permits. Officer Miller is going to present to you on it today, and I'll just turn it over to her. She does such a good job.
Good afternoon. Alex Miller, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: copy of the observation notice, copy of the courtesy notice sent by regular mail, copy of the notice of violation sent by certified mail, copy of the statement of violation and notice of hearing sent by certified mail, posted at the property and City Hall, copy of the PowerPoint presentation, affidavit of posting, evidence of mailings, copy of the sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate find the respondent in violation in the amount of $390.89. The respondent is here. On March 19, 2025, Code Enforcement received a complaint regarding a single-family dwelling that had been divided into several apartments, which were being advertised for rent. I was able to verify the online listing, which advertised both the individual apartments and the detached garage that had also been converted into an apartment. There were no permits on record for these conversions. I contacted the owner, who stated that he was at work and he will call me back later. An observation notice was sent by regular mail to the owner, and 8 photos were taken. This is some of the unpermitted work he did. A water heater, fixed some of the deck around the property, as well as new AC. And this is the listing, some of the pictures I was able to find online that were advertising for rent. March 24, the owner came into the office to obtain information about correcting the violations. I had advised him that he would need to apply for the necessary permits and hire a licensed contractor to address the work that had been performed. On April 1st, a reinspection was performed, and it was verified that no applications were on record in the system. A courtesy notice was sent to the owner by regular mail, advising him to correct the violations. On April 14, I verified that the property was still in violation. A notice of violation by certified mail was sent to the owner. On June 3rd, I verified that an incomplete application was submitted, and it was disapproved due to missing information. on July 17, July 14, August 11, September 8. Several emails were exchanged with the owner and the contractor requesting updates regarding the missing information required by the city. I was advised that they were working on providing the necessary documentation. Additional time was granted for the permit to be obtained. On October 31st, a reinspection was performed and verified that since August, no additional information has been submitted to the city, and the property is still in violation. A statement of violation and notice of hearing was mailed by certified mail, posted the property in City Hall. An affidavit of posting was created, and 2 photos of the posting were taken. On November 14 and today, I verified that the application is still showing disapproved status and because it's missing information. It is the city's recommendation that the respondent be found in violation of allowing work to be performed prior to obtaining permits and not meeting the zoning conformity by the time specified. The city will recommend that the respondent be given until December 12, 2025 to obtain the permits or remove all the work performed, or a fine in the amount of $250 be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $390.89 to be paid within 7 days of the written order by the special magistrate, and this concludes my presentation.
Thank you. The respondent?
How you doing today, sir?
Good, how are you?
Good. Thank you, Alex.
Maybe start with your name and name in relationship to the property.
Yes, Anthony Kanan. I'm the owner of the property.
Okay.
So, yeah, we've been speaking with Alex for a bit. I know, we've communicated, and I did hire an architect and a contractor as well, not to beat a dead horse like the last guy, but architects are just taking absolutely forever to do things. This guy has received a lot of notes from the permits applied for and has just been, not responding. And
Where are you in the process? To the extent that you're able to, how can you help? How can you help me understand where in that communication with your team you are in getting what you need to get this resolved?
Yeah, so I'm more in contact with the contractor than I am with the architect. And the contractor told me, the architect's portion is not my job, so you're going to have to get in direct contact with the architect and kind of push him along so that we can do what we need to do. So I've already paid the architect money. I think I just need to be more intentional with the architect so that he can get done what he needs to get done, and so we can move along with the process.
Well, like you heard me, we're not there yet because I still haven't ruled, but there will be a ruling today, and assuming that it is to find that there's a violation and I order you to do something, just like you heard me tell the last respondent, when you get that in the mail, the first thing I want you to do is send that to your architect and say, a little bit more than what I told the last respondent, not just say this is impacting my pocketbook, but if it impacts my pocketbook, I'm going to make sure it impacts yours too, because you have that right. You have hired them to do a job. It is their responsibility to do that job for you.
Absolutely, yeah. I'm a St. Cloud resident, lived here for a long time, love the city. I definitely don't want to be in non-compliance with something. I want to do what needs to get done, and if I could do it with my own physical hands, I would do it, but I don't know how to do any of that stuff. So.
And again, corporate ownership, you would not be able to anyway. You have to use a contractor because of the corporate ownership.
Right.
So again, city has asked for December 12th, one, to be consistent, and two, based on what I'm hearing, I'm also going to extend your compliance date to January 19th. Very important, get on that architect early and stay on him until you have those
Yes, sir.
plans. Because until, the contractor's telling you right, until they have those plans, they cannot come to the city and get those permits.
Yes,
It's a
sir.
beautiful looking deck. I want you to be able to keep it.
Yes, sir.
Because that is as you hear in the presentation, one of the options in resolving non-permitted work is to remove the non-permitted work, but I don't want you to have to do that with that deck, and I also don't want you to have to pay $250 a day because other people aren't doing the job that you've hired them to.
Yes, sir.
So stay on top of them. Is there anything else you'd like me to hear before I rule on the case?
No. Thank you.
Based on what I've heard, then, I will find in favor of the city, find that there is a violation as described in the notice of violation. I will order the respondent to cure that violation by January 19th, 2026. If not brought into compliance by that date, A fine in the amount of $250 per day will run until compliance is met. We'll also order the respondent to pay the administrative costs incurred by the city in the amount of $390.89. That amount will also be due January 19th, 2026.
Thank you, sir.
Sir, and as you've already heard me say, there will be a written order. You'll have that in the mail, and again, get that to your architect as soon as you get it from me.
Thank you, sir.
Case number 2025-769, Rachel Ruffin, owner, location of violation 501 Kentucky Avenue, St. Cloud, Florida.
Mr. Smith, I'll just turn this one over to Officer Miller. She'll present to you a case on these land development code violations related to, again, work without permits. Officer Miller.
Good afternoon again. Officer Miller for the City of St. Cloud. At this time, I would like to enter into evidence the following items: copy of the observation notice, copy of the courtesy notice sent by regular mail, copy of the notice of violation sent by certified mail, copy of the statement of violation notice of hearing sent by certified mail posted at the property and City Hall, copy of the PowerPoint presentation, affidavit of posting, evidence of mailings, copy of the sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $342.48, and the respondent is here. On August 20, 2025, while verifying another complaint, I observed that the property had high grass and weeds, overgrown vegetation, and the dwelling was missing the street numbers. An observation notice was issued to the owner, and 2 photos were taken. Sorry, 3.
So these photographs, you're showing me the high grass and weeds.
Yes, sir.
Are you seeking
And
any
the re-
relief as to the high grass
No,
and weeds
sir.
today? Just so I
No.
understand, okay.
Yes, sir.
I don't want to interrupt you, flow however you need to with your presentation. I just wanted to make sure I understood what I was being
Yes.
asked to rule on today.
Yes, sir. On September 3rd, a re-inspection was conducted, and I observed that the property remained in violation. I also noticed a sign on the door of the accessory structure located in the rear yard advising the landlord not to enter the rented property. Additionally, I observed that a deck had been added to the rear of the main dwelling without permit on record. I verified that the owner applied for a permit in 2024 to convert the accessory structure into a living unit, but the permit was never obtained, and the permit is now in abandoned status. A courtesy notice was sent by regular mail, and 5 photos were taken. This is the note from the tenant saying that the landlord should not enter the property. She also had a for rent sign in the front yard. The weeds, and the deck and the rear of the house, the weeds. On September 10, Officer Bennett and I met with the owner of the property, and she requested an explanation regarding the violations. I advised the owner of the violations and explained on how to correct them. 4 photos were taken. The deck, the grass and the weeds, vegetation. On September 17, I verified that the property was still in violation. On September 18, a notice of violation was sent to the owner by certified mail, and 6 photos were taken. This is the property before she bought it. This is accessory structure. This is the accessory structure that's located in the rear yard. And she added sliding door in the front. And this is the rear property without the deck. And this is the deck that she added to the back of the property. On November 5th, a re-inspection was performed and observed that the grass had been mowed. However, no permits had been obtained, and the property remained in violation. A statement of violation and notice of hearings was sent by certified mail, hand-delivered the notice to the property owner, posted City Hall, and an affidavit of posting was created, and 3 photos were taken. This is the rear the accessory structure located on the rear yard, and somebody's living in the accessory structure. November 14, and today I verified there's still no permits on record. It is the city's recommendation that the respondent be found in violation for allowing repairs and alterations to be performed prior to obtaining the required permits and for failing to meet the zoning conformity by the specified deadline. The city recommends that the respondent be given until December 12, 2025 to obtain the necessary permits or remove all unpermitted work. If compliance is not achieved by the date, a fine of $250 per day should be assessed until compliance is met. And the city also requests that the cost incurred in bringing this case before the magistrate in the amount of $342.48 to be paid within 7 days of the written order by the special magistrate. And this concludes my presentation. Sir, I also have attached the permit application that had been abandoned in the folder. And when she requested to turn that into a living unit, and there were some impact fees that were required to be paid in order to convert the structure into a living unit.
So that I understand, then the permits were issued by the city but
No.
never picked up.
She applied, she put an application, but when she was advised that she will have to pay some impact fees, she then did not proceed with the application, and the permit application has been abandoned since 2024.
So no permit was ever issued?
No, sir, not for the deck or the accessory structure. For the
So-
deck hasn't even been applied, sorry.
There was never an application made for the deck. There's no
No, sir.
record of an application for the deck.
No, sir.
And as to the
Accessory structure, there should have been.
accessory structure,
There is an application, but it has been
application
abandoned.
for permits, was it never processed?
Was
because of the impact?
processed, but then she didn't finish the process when she was advised that she had to pay impact fees.
I think you can get some help.
Okay, sorry.
Thank you. Okay.
And so she applied the permit in January 4th of 2024. And then,
I'll tell you why I'm asking, what I'm trying to
Yes, sir.
understand. Were there any zoning or other issues that prohibited the issuance of the permit, or was the only issuance for the application abandonment the issue regarding impact?
no,
There was-
she needed to provide additional information. Okay, go ahead.
I haven't been
Yes,
sworn in.
yes, ma'am. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
And if you'd start by saying your name and title for the record, please.
Tisha Manning, zoning manager for community development. So, yes, so she applied for the application in January of '24. So just looking at the review comments on the application, it did have several disapprovals from building, civil site, as well as zoning and impact fees. Currently, right now, the application is abandoned status, and the total amount that would have been due for this application for that unit is $55,560.70.
Okay, and the reason why I wanted to get onto the record and into the conversation, the 2024 permit, so that everybody is, because my job is to find, is there a violation and what's going to be done? If I do find there's a violation, what needs to be done to cure it? And in a permit application situation, one of the things that can be done is to obtain permits. And as I'm looking at the 2024 permit, or the application, the abandoned application, I question whether or not this structure, where it's located, would be able to be approved. And I just, so that when I engage in conversation with the respondent, that I'm kind of doing that with an understanding that this may not be something that could be permitted, at least where it is. Am I understanding correctly?
So we
I know
do-
you can't answer that question until you have an actual application to review, but just so that I can kind of help her understand her options, am I understanding correctly that there is probably a pretty good chance that this probably can't be where it is as it
It can
wants to
actually
used?
be permitted. We would, of course, have to look at setbacks and things like that, but understanding that it was already an existing accessory structure, it more than likely already adheres to the required zoning setbacks. So she may be able to convert that into a residential dwelling. She would just have to go through the proper
Okay,
process.
okay. That's where I was trying to get to so that I understood that.
Yes,
Thank
sir.
you. If there's nothing else, I have no further questions for the city right now. Ms. Ibarra? Even though I know who you are, if you would state your name and your relationship to the property for me.
Hi, I'm Rachel Ruffing. I'm the owner of the property. Thank you so much for taking your time today to allow me to speak. I have several things I'd like to talk about. We can start with whichever one you'd like. The
Start where
deck.
you want to.
When I bought the house, the deck was already there. It's been there for 5 years. It's not attached to the house, it's floating. Alexis had observed it, but if you look at the property pictures that she had just provided, that was, I don't know what year they were taken, but it was prior to when I purchased it. When I purchased it, it was already there.
Let's pause there. Can we get back to that photograph that she showed so that we can
Please.
all see it?
What year was that?
That was I have to look at my records, but that was when she actually purchased the property. I got it from Zillow, when she purchased the property.
Okay, but do you know the date of the photo? Do you know what date that, I know when you might have looked at the photo, do you know that the date that Zillow took the photo?
No, sir.
Okay, so you do not know the date that this photo.
Correct.
Let her answer, please. Okay? Yes, sir. No, you're fine. I don't need the
I
background
don't.
commentary, please, okay? Respectful, okay? I'm talking to you, yes.
Oh, yes, I don't know.
When
Oh.
somebody else is testifying to me, I don't need you giving,
Okay, I
commentary,
apologize.
okay?
I just,
Thank you.
I don't know when that photo was taken.
I know, but I was asking her is the
Oh, I
point.
thought you
When
were
I'm
talking
asking
to
her a question, I don't need your, I don't need your motions when I'm asking her a question. I've had the answer to the question. That's been resolved. Okay, you may continue. You may continue.
So when I purchased the property, the deck was already there, and it's been a floating deck. It's not attached to the home.
Whether it's floating or not, that has no bearing on the permitting issue. The timing to me does, so that's why I'm interested in that issue.
And I don't know when it was done, so I apologize for that, but I just don't know. This photo was taken off Zillow. When I purchased the home, it was already there.
Okay, now, can I get you to roll forward to, I think it's the next photo in the series, but it's the one that shows the, what am I, from respondents, but what am I looking at in this photo?
Are you asking me?
Yes,
that?
I'm asking respondent, what am I looking at in this
That
photo?
is a side view of where my deck is. So I have a tarp up for privacy. It's just a side view of the deck.
Okay, so that's just a privacy screen that
It's just a
I'm looking at
privacy
there.
screen that I built like a little screen or whatever, and then I put the tarp over it, just so I didn't have people looking into my yard. So the deck was already there.
Okay, you may continue.
What would be the next issue that we have to talk about, please?
It's your case you are presenting to me. I'm not going to tell you how to make it.
Okay, let's go to the apartment. If we could. She said that I had people living there. Actually, what I did was I took 2 homeless people from City Hall, and I let them come to my home, and they live outside of my home, so they didn't have to live at City Hall. And so they stay in my backyard for free. And that's the picture which she had of them with a table. I let them live there in my yard for free.
Okay.
Their names are Richard Borshik and Gordon Melling.
Okay.
So if you'd like to provide the picture, if you wouldn't mind, please. The chairs, I let them sit in, but that's their stuff right there. That's their stuff. They stay in my backyard. So they're not at City Hall. And if you don't, there's an officer that they know. I don't know his name, but if you need validation for that, I can bring them here so they can tell you that they have removed themselves from City Hall and they are now living in my backyard. That is their thing.
Question for the code enforcement officer. The chairs were related to your case, Hal?
That was just proof that it appears that somebody was living there, but I actually was there on Monday, and the door of the apartment was open, and I see mattress, and somebody was staying inside, and they shut the door before I could take a picture, but somebody's staying in there, living in there.
Okay. And is the zoning portion of the case violation of single-family zoning? Is that the, the zoning department is coming up.
Tisha Manning. So the zoning conformity is because anytime you convert any type of accessory units into a dwelling, then you have to go through the permitting process, which she did apply for. She just did not complete. So at this time, she's continuing to use it as a dwelling, but hasn't completed the
But
process.
you are not presenting the argument that the property is being used for other than single-family residential. That is not
Correct.
part of the case. That's what
Correct.
I wanted to get to. Okay,
Yes,
thank
sir.
you. And Ms. Ruffing, you may proceed. Actually, I have a question to you. So you say that these two people are living on your property.
They are living in my backyard,
Where do they sleep?
in the backyard.
Do they ever sleep on the deck?
No,
What if it's raining?
they go
You
to
are
City
sworn and
Hall.
under oath. If you lie to me, it is perjury.
I understand. They will go to City Hall, or I will let them in my house.
Have they ever slept on the deck?
No, they sleep inside if I want to bring them in, if it's raining or cold. But most of the time, they will go back to where their camp is. It's where they keep all their stuff. They call it camp. But I let them stay in my yard, and a lot of the time, they'll sleep in the alleyway too. So I'll give them blankets and pillows and provide for them, and
You can proceed. Did you have anything else? You can proceed.
okay. We were talking about the ADU portion of it, where I applied for the permit. It was because it was converted into a mother-in-law suite. And so
When was it converted into a mother-in-law suite?
I'm not quite sure. It was, I'll be honest with you, Alexis, and I'm so sorry to say this to you. I feel like she's been harassing me for a little bit, and she keeps coming to my house all the time and asking me to do things. And I'm like, what do you need me to do? She said, I need you to go get a permit. And I said, for what? She goes, well, you have to convert this into an ADU. So I went down last year and I applied for it because this is what she told me that I needed to do. She has been at my house for a very long time. And I said, I don't understand why I need to apply for this. So I did. And so I was like, okay, we're going to convert this. And it was after they had just passed the law to make it, because it was just like a mother-in-law suite or whatever. And she's like, you have to convert it into an ATU so you can rent it. And so I went down there to do it. And then after I did it, they said there was impact fees of $55,000. And I said, well, I cannot pay the impact fees of $55,000, so I don't understand why I have to have a permit to do this. And so this is when I abandoned the permit, because I couldn't pay the impact fees. I have a unit that's on my property, which I'm allowed to use because it's mine, and nobody lives there, but it's my space. I'm allowed to use it for whatever I want to. It's not rented. She saw a for rent sign, and she said that she saw it, but that is for the inside of my regular home. It doesn't mean that it's for the unit. I tried to rent it at one point. She told me I wasn't allowed.
When did you try to rent it?
There was a lady I let live there.
When?
And it was last year.
So about the same time that you just told me that she told you you had to have an ADU and you didn't understand why.
No. I'm sorry, excuse me. The beginning of this year. We're in 2025, okay?
Okay.
So I didn't know that I wasn't allowed to do it. She said, you can't have anybody living there. I said, you have to leave. I had to evict the lady because she wouldn't leave, because I had to.
So, again, so that I understand what you're telling me, because I'm starting to hear inconsistencies, you told me a minute ago that in 2024 you applied for a permit because you were told you needed to make that into an accessory dwelling unit.
That's correct.
You just told me that you didn't understand why you couldn't have somebody living there in 2025.
Well, I didn't know that I had to have a permit to have somebody living there while I was doing an ADU. I thought she was making me make it an ADU, but it was still just a mother-in-law suite. So I didn't really understand the difference between the two. It was my space, and I was letting somebody live there, and then I had to evict her based on what she told me I needed to do. And here we are.
Okay, I'm trying to understand, again, the gaps in the testimony. Because on one hand, you just finished telling me that you didn't think you needed an ADU. She kept on telling you needed to have an ADU. You didn't think you needed to have one in 2024.
Correct.
To explain the permit application that I have in front of me.
Correct.
But then we get to
because-
2025, and you tell me you were renting it to somebody to explain the for rent sign, but then immediately after that, you tell me, but I didn't understand why I couldn't rent it to somebody. Did you not remember the conversations about the ADU?
There's a difference between an ADU and a mother-in-law suite. I'm allowed to rent things on my own property. I thought that I had to convert it to an ADU, and this is why I went through the process of doing it. But they asked for me to do driveways and pay impact fees, and I thought that that's what I had to do just to rent my
As you understand it,
space.
what is the difference between a mother-in-law suite and an accessory dwelling
I'm
unit?
going to
As you-
let her explain that.
No,
because
no, no,
don't
I
know.
want, but I want to understand your understanding of it. I'm going to ask them their understanding of it, but I want to hear your understanding first.
I didn't know the difference, to be honest with you. I only did
But
what
you
I
just told me
thought.
there is a difference.
There is a difference.
What do you understand that difference to be?
The difference is I'm supposed to do an ADU and pay impact fees and have a renter's license, which I didn't know that I needed, even though I had somebody living there, because it was just a mother-in-law suite, and I'm allowed to have people in my property.
Okay. But you just told me, you told me there's a difference between an accessory dwelling unit and a mother-in-law suite. What is it that you understand that difference to be?
To be honest with you, I don't really know the difference. They were telling me that I had something that needed to be different from what I had. I have a mother-in-law suite where I was letting a woman live, and they told me that I wasn't allowed to have her live there unless I converted it to an ADU. So I applied for the permit.
So let me understand, that's in 2024 that you're talking about.
Well, yes.
So, and you just told me that in 2024, you understood that you could not have somebody living there unless
no,
you had
no.
an ADU.
I'm sorry, pardon me. They said I had to have an ADU, but I didn't need to have an ADU because I was allowed to have a mother-in-law suite.
And that's the point that I'm trying to get your understanding of. Why do you keep telling me that?
Because I abandoned the permit for an ADU because of the impact fee, so I didn't think I needed to have that
But-
because they wanted me to do different things, but it's still my property, so I could rent it.
Your argument is based on, you are telling me there's a difference between accessory dwelling unit and mother-in-law suite. And I'm asking you, what is that difference in your understanding so that I can understand the parties' positions in this case?
If I can be completely honest with you, it would just be the city's difference because my home
I need
is
to know what
just,
your position is. I can't know if there's a difference unless you tell me why you believe that you don't have to have an accessory dwelling unit to have somebody living in the accessory dwelling.
because it's just a mother-in-law suite.
And what is the difference between a mother-in-law suite and an accessory dwelling unit in your understanding? Why are you telling me there's a difference? Make the argument is what I'm asking you to do. If I was in front of a judge and I told the judge something and the judge said, help me understand why that argument should prevail, Mr. Smith, that's what I'm
The accessory
asking.
dwelling unit is supposed to have a driveway and has to be 10 feet on each sides and all these other things that require permits and stuff, but it's already been there since 1982. It's just a mother-in-law suite. It's just a place where people can go. If I want to go in there, I can go in there. My kids can go in there. I don't really know the difference. So the only thing I can say is she asked me to apply for a permit for an ADU, and I did it, and I couldn't afford to pay for whatever it was, but it's still my property. It's still it's still something that I own. It's mine. It's been there since 1982. I'm allowed to have people in my space. So I really just don't know why they wanted me to convert it. I can't pay for that.
Now, if I could just take 2 steps aside, I'm going to ask planning to come up. And from the city's perspective, is there a difference between mother-in-law suite and accessory dwelling unit?
So an accessory dwelling unit is a space that is used for living. And from what I'm understanding, she is renting that out, so it is being used for living. It contains, I don't know what it contains, I'm gonna be honest, I don't have any photos of that, but it is, if it is classified as a dwelling, which means it has a bedroom, a bathroom, kitchen, then it is a dwelling and is considered an accessory dwelling unit and then therefore has to be permitted. I can pull up the exact definition of accessory dwelling unit.
Mr. Smith, if I could.
Yes, Mr. Manzarek.
Ask Ms. May. Is there a definition in the city code for mother-in-law suite?
No, sir.
So for purposes of, the term mother-in-law suite is a common vernacular term that's used. The city code refers to an accessory structure being used for living quarters, and it doesn't matter whether it's a mother-in-law or a neighbor or anybody else. And so there is no distinction within the city code between the word that the phrase that the respondent has been bringing up, mother-in-law suite, and an accessory dwelling unit. The city considers them to be the same.
A mother, to play the elementary school logic games, a mother-in-law suite is always an accessory dwelling unit. An accessory dwelling unit may or may not be a mother-in-law suite.
That's probably
Mother-in-law suite is a form of accessory dwelling unit.
Yes, sir.
And that's consistent with my understanding. So before planning leaves, I think I have another one for you. So you testified that an accessory dwelling unit has a kitchen,
1 second, please. Just going to pull up so I can give you the exact definition. It's hard when you're working under pressure.
always is, I know the feeling.
Okay. So a dwelling is a building or portion thereof designed exclusive for residential occupancy, including one family, two family, or multifamily dwellings. And then it goes on to say that it must include a self-contained living unit containing sleeping, living, sanitary, and kitchen facilities.
So kitchen and sanitary, key components here.
Yes, sir.
Does the city have any evidence that this dwelling unit, that this accessory structure has kitchen or sanitary facilities?
In the folder, I was able to find some information, some pictures when she had posted the property for rent. She charges $1,000.50.
I think you had those in your presentation. Can you go to those
No, I don't have it here, sir. I didn't include the pictures in the presentation, but they're on the package I attached to your for evidence.
Is it this?
Correct, the ones that have the pictures.
Are you sure you didn't show these in your presentation?
No, sir, that was in the other 606
the prior
Pennsylvania.
case?
Yes, sir.
It's very similar. Okay, ma'am, I'm going to ask you to, oops, I'm going to approach you. I'm not going to make you navigate over here. First question I'll ask you about those photographs is, do you recognize what they're photographs of?
Yes, sir, I do.
And what are those photographs of?
Of the mother-in-law suite that I have.
And does that contain kitchen and sanitary facilities?
It has a refrigerator and a sink, so no.
Okay, does it, now moving from beyond the photographs, then does that, what you're calling a mother-in-law suite, does it contain a kitchen?
It does not.
Does it contain any cooking appliances?
It does not.
Okay, does it include a bathroom?
It has a bathroom, yes, sir.
Okay, is it what kind of bathroom is it? Is it a full bath or half bath?
It is a toilet and a sink and a shower.
Does it have a range?
It does not.
Does it have an outlet for a range?
No.
Does the city have anything to rebut that testimony? No. Moving away from the use of accessory structure into the permitting, what alterations, is it just the deck itself, or are there other alterations to the deck that code enforcement is presenting to me?
No, the deck just was built without permits, and inside so there's no permits on record even for the accessory structure for electrical, plumbing, for the replacement for the, adding the sliding door in the front, none of that has permitting. So even if, I don't know if you want to add anything, but there's no permits on record for
Okay,
anything, anything.
I see council has something for me. Before we get there, let me, while that's fresh in my head, I want to ask the respondent a question about what Officer Miller just testified to. Ms. Ruffing, there is the glass door. Is it your testimony today that the glass door installed on the structure was prior to your owning the property?
That's correct.
And when did you buy the property?
Actually, my stepfather bought it and he put it in my name, so I've owned it, but I've only been there for about 5 years.
And when was it put into your name?
Like I said, 5 years ago, so 2019, I think. What are we?
And so that sliding door predates 2019?
I have to do the math, but it's there.
It predates your ownership?
As far as I know, sir, yes.
This is a critical point for me, so I need, is your testimony that that glass door predates your ownership of the property?
I am not aware of any alterations or repairs prior to this, but if he made them, then he did. I wouldn't have known.
Okay, would those repairs have been made prior to your ownership of the property?
I would say yes, possibly. Like I told you, he just put the house in my name.
Okay, I guess you take 2 steps aside, and Mr. Manzares, you had something to tell me, I
Well,
think.
you asked the question regarding the city having any information to rebut the testimony related to the accessory unit that's out there, and I think Ms. Manning has some information that might be relevant to that piece with regard to the things.
Before we get back to the accessory unit, why I'm asking the line of questioning that I am as to the timing of any alterations was I'm trying to determine whether or not this falls into the category of that 2-year-old statute, I think now, where the legislature dealt with the prior owner alterations, where if there's not a safety issue, and I'm trying to see where this situation fits into that statute, because the legislature has created, it's resolved this issue that some old properties that have old alterations where permit records no longer exist, and it was unknown whether or not there was never a permit issued or if the permit just was no longer of record anymore. And the legislature dealt with that by saying, if I remember it right, that before a certain point, that if there were alterations made, if there was not a safety issue, then there was not clear whether or not there was a permit or not, or when those were made, that those were not, or those fell into a special category in code enforcement and not into the old categories that we used to take in code enforcement, which was don't care if you had a permit, don't care if you owned it when that was done or not. The fact it still has to have a permit, and that has been pulled back a little bit by the legislature. I'm trying to figure out where this fits in that.
Well, my understanding of that intent of the legislation was to go back before there were records related to permitting to deal with some of those older issues where most municipalities didn't have records going back 40, 50 years.
Yes.
So the city has maintained records back from when this property was built, which I think the respondent said was about 1985, I think she said. Okay, so the testimony through the code enforcement officer, there is no permit for that deck. And that's already been our testimony. That was the basis of temporary. The other point is, and I would ask the respondent, so how long did your stepfather own this house?
He originally purchased it.
Yeah, I'm sorry, we need to swap you so we can have her on the microphone. Mr.
Oh, I'm
Manzares.
sorry. I should know better.
Like I said, I think he originally purchased it in like 2018 or 2019. He just put it in my name.
So I do believe, Mr. Smith, that
Well, and we were getting there. That was coming out. I was kind of going the same place because even what I'm thinking, that was for a buyer in good, or a bona fide purchaser, commercial purchaser, as opposed to this, a property being handed.
right, and that was part of, that was what we were going to
Yes, sir.
address. So that was that point.
And
if
planning, yes,
if
planning had
Ms. Manning
something.
could address the plans that were submitted with regard, assuming those are the plans that when they filed for the ADU permit?
Yes. So I do have the plans that were submitted with the permit for the accessory dwelling unit, and it does show the installation of a 220 volt. I don't, again, the application was abandoned, so she may not have gone through with these actual plans, but it does have the 220 volt, which is for the stove, as well as, looks like a outlet for maybe a dryer as well, because there's two 220 volts shown on the plans.
Okay. And remind me the code language again for the accessory dwelling unit. Was it cooking facilities or was it a kitchen? How did it phrase
Cooking
that?
facilities.
Okay. Okay. Ms. Ruffing, your turn again. You heard that issue raised. So in the permit that was submitted in 2024, there was included in that permit, there would have been the installation of the range voltage. Was that ever performed?
No, sir.
Okay. Because the code is cooking facilities and not kitchen, I would interpret kitchen to mean the range. Are there any countertop, normal standard voltage appliances that can be used for cooking in that dwelling unit?
No, sir.
And it is your testimony to me today that no one is living there?
No one is living there.
No one is sleeping in there, not
No one
even
is
on
sleeping
a
there.
rainy night?
Not
Not
at
anyway,
any time.
not ever?
Not ever. It's just used for cover and shelter for the two friends that I found at City Hall.
You say is the accessory is the accessory unit being used for cover and shelter for your two friends?
Only if I let them go in there for a mediocre amount of time. They do not
What
live
is a
there. They
mediocre
don't stay
amount of
there
time?
an hour at the most. They don't use the facility, but they are homeless, so sometimes they have to put food in my refrigerator.
So they're keeping food in your refrigerator? Do
They
they
might-
come and go at their leisure?
No, it's locked, but
Do
they
they
might.
have a key?
No. I'm the only person that has a key. Nobody stays there, it's just me. It's my
Do you
mother-in-law.
ever keep it unlocked?
I do not.
Mr. Manzares?
May I see the pictures, please? Well, Mr. Smith, we have a couple points on this so we can just clearly understand what we're talking about. And I think your recent line of questioning got to where we're. First step is, regardless of whether this is an ADU, it's set up with living quarters, people cannot be living in those premises. They cannot be living in premises. I frankly think it is a little unreasonable and somewhat disingenuous to basically say I have people living in my yard. I have a completely built out, as you can see from the pictures, apartment unit with a full shower, a refrigerator, sink, a spot for what looks like a dishwasher, and cabinets, sliding glass doors, nice hardwood floors, and all that. And individuals are I'm going to let individuals live in my yard. She also testified that at one point she did have a tenant in there that she had to evict. So we do think that there's evidence that these premises have been used as an unpermitted accessory living unit. And she has plenty of time to come in compliance. All she got to do is make sure nobody's living there or go get a permit. And then we can address that issue, and there won't be any issue with regard to a code violation. But I think these pictures are clear that were part of the packet. This is a built-out accessory unit as what looks like a one-bedroom, maybe a studio type of apartment. So we just want to make sure that she realizes that after the compliance date, if you are to still find, she can't have anybody live in there unless she wants to get a permit to permit it as an accessory dwelling unit.
I think we're probably approaching closings here on this one. Ms. Ruffing, anything else that you would like me to hear before I rule?
If I may, I can have my husband send you pictures of the current state of the ADU, which shows that no one is living there, and there is no stove or anything, and no one is inside. There's nothing in there.
It's not necessary.
Okay.
So if I could just say, this Zillow ad that was on these pictures came from, Redfin. Was that something that you posted?
That was when I had the woman that was living there, but then I was told she wasn't allowed to live there, and then she squatted there, and I had to evict her because the city told me that she wasn't allowed to live there. So I had to pay the money to go down to Osceola County and evict her to get her out because I didn't know that she wasn't allowed to live there.
And so, Mr. Smith, if I may, we can change our recommendation a little bit if it's okay with you, speaking out of turn.
I will entertain, I will listen.
All right, so with regard to the unit structure, I think the testimony is clear that at one point there was an individual living in that thing. The respondent just did that. If you are inclined to basically find that as we sit here today,
And that
the
is,
property is not.
that actually is what I am inclined to find. Is
Living, that the property was at least in violation in the past, it is in compliance today, and if necessary, we will bring it back as a repeat violation.
And that actually is going to be my finding. That's exactly where I was headed on that, because I think based on the evidence that's been presented today, I have this referee testifying to me, nobody is living in that unit today. I do have struggle with the same issues that have been raised throughout this hearing, and I would say this: if you have two people that are living in your yard, and if at some point of the day they are allowed to use that unit, it is being used as a living unit. If you were telling me they are residing on your property and that is one of the spaces they use for any portion of the day, that is being used as a living unit. And I do find that that was a violation. I accept your testimony today that it is not going on anymore. The significance of that, though, is if it happens again, and we have another case about this with the same testimony and the same evidence being presented, and I find that you have two people living on your property, and they're using that, whether they're, it doesn't matter to me if they spend 23 hours of the day outside and 1 day in there, it is being used as a living unit for that portion of the day. It is being used for them to take care of the living aspect of life, I'm ruling now, and I don't need to hear more. They're keeping their food there, they're showering in there, they are using that as a living unit. So the significance of this is, I'm not finding you in violation of that anymore, I am finding that you have been in violation of that. If it happens again, though, and if there's another case brought, and I find again that it's a repeat violation, I can fine $500 a day for every day back to the first day it was first observed, the next time, the new time. So it's very important to resolve this issue. I also alluded to something else that I want you to understand. Inside or outside, your property is a single-family property. That means you can't have unrelated people living on the property, whether they live indoors or outdoors. That's not the case code enforcement brought today, and I am not ruling on that, but I am encouraging you to understand the legalities of what you are doing, because it could end up costing you. As to the deck, the fact that it was passed to you as opposed to you being a bona fide purchaser has resolved the one issue I had on the timing of that. That deck needs a permit. And I'll explain to you why a deck needs a permit. I shouldn't have to explain to anybody who lives in Florida, because we all know that about once a year we're at least going to have one big storm. We, knock on wood, we don't get a really late one. We got really lucky this year. When hurricanes blow through, they have a tendency to lift things up and throw them onto somebody else's property, somebody else's house, somebody else's head. That's part of why Florida has a very strict permitting process. That deck needs to go through the permitting process to make sure that it is safe for you, safe for anybody who may be on it, and safe for the neighbors to make, if wind ever gets up underneath it. Can you understand that?
Yeah, my house is on the market for sale because I just got laid off from my job, so may I request some additional time?
You will have to tell any potential purchaser about this code case and the ruling, because they will inherit this order. Okay?
Just like I did.
A little bit different, because you have a duty under the statute that once there is a code case brought, until that code violation has been cured, and especially once one has been found, you have an affirmative duty to tell any potential purchaser about that. If you fail to, and if the sale closes, they can come back and undo that sale and impose costs against you for having to do so. So it is very important to be upfront with purchasers.
I will.
So that is my ruling. I do find that as to the accessory dwelling unit, that based on the evidence testimony presented today, I do not find that, as we sit here today, there is any violation. I do find that there was a violation prior that has been cured. Any future violations may be prosecuted as a repeat violation. As to the lack of permits for the deck that exist, I do find that that is a violation of the code. That violation must be cured. Code enforcement has asked for December 12th. I will do the same thing that I did in the other two cases, and I will give until January 19th to have permits in hand for that deck. And it may be, unlike the others, that the work may not have been finished yet, It could be as simple as after-the-fact permit, inspection, and you're done. So it may not be that complex of a problem for you. And also, unlike the others, you are individual owner. You potentially could come in for owner-builder, I think. I can't tell you that for sure, but I suspect that as individual owner, you could be. No.
I can't do it because they said if I did it, I couldn't sell my house for 1 year and my house was on the market.
That's right.
so-
I wasn't thinking about that, and you had the house on the market. I had forgotten that the house was on the market. Thank you for reminding me. We'll order the administrative costs of prosecution in the amount of $342.48 be paid within, I will give until January 19th on that also. 2026. If the permit violation is not cured by January 19th, 2026, fine of $250 per day, like you heard on the other cases, will accrue from that point forward.
Thank you, sir.
Yes, ma'am.
Reduction of liens under 50,000, case number 2020-218, Progress Orlando LLC owner, location of violation 4593 Ballard Trails Drive, St. Cloud, Florida.
And Mr. Smith, if we could, I believe there is a respondent for the last item on the agenda here, and there aren't responders for the other case. So if you're okay, we could maybe jump to that one.
By all means.
Reduction of lien over 50,000, case number 2023-1789, Jamie M. D'Amico, owner, location of violation 1512 Connecticut Avenue, St. Cloud, Florida.
And thank you, Mr. Smith, and the clerk. As a clerk read in, this is a lien that exists in excess of $50,000. It has to do with abandoned vehicles, accumulation of truck trash and debris. The property was in front of you in October of 2023, and a compliance date was set for March of 2nd of 2024. The property ultimately came into compliance in September of 2025 with a fine that had accrued at $250 a day. Total fine accrued to $142,755.70, which includes $255.70 of administrative costs. Again, this is your review for recommendation to the City Council for final approval. The City Manager has looked at this, and we've discussed it with the City Manager, and is entertaining a offer from the respondent's representative to reduce the fine to the amount of $5,000 pending a payment within 7 days of the approval. Within 30 days of the approval by the City Council. For your information, it's our understanding that the original respondent in this property is deceased, I believe, and the representative respondent may have been the sole heir, but at least took possession of this house, this property through the estate.
And then do I also appropriately take from that is part of the city's reason for as significant a reduction as is being
Yes, sir.
recommended?
That's exactly the reason for it. And again,
That was going to be my question. Is it a significant reduction, and why?
It is, and we will have to explain that to the City Council because they are particularly interested in these kind of cases. And I'm going to mispronounce her name, but Ms. Schiavini is here, and she's, I'm sure, ready to address you. But she has signed off on this, that she's okay with the reduction to $5,000.
And ma'am, you do not have to testify. I have enough to rule, but you're welcome to if there's anything you'd like me to hear. I won't make you if you don't want to, because I have enough here to approve what has been requested. Okay?
I mean, I don't mind speaking, but
Only if you want to. I don't want to, you've waited this long. I want you to have your turn at the microphone if you want it, but some people would prefer not to have a turn at the microphone. If you're going to talk.
probably cry. It's been a mess and difficult, so.
You're good. You're good. Based on what's been explained to me as to the reasoning behind this reduction, I will recommend approval to the City Council. Do I have these, by the way?
There, yes. December 11th, yes.
Thank you.
Reduction of a lien under 50,000, case number 2020-218, Progress Orlando LLC owner, location of violation 4593 Ballard Trails Drive, St. Cloud, Florida.
And again, this is another request for reduction. This one is under 50,000, so it's entirely within the authority of the special magistrate. The original violation on this property was basically an unpermitted fence on the property. It came in front of you on, I don't know, August 19, 2020. Were you serving as special magistrate then?
Yes, I was. Yes.
Okay. Time flies. And was set to be cured by August 31st of 2020. The fine accrued at $250 a day to a total of, including administrative costs, of $37,714.40. After discussion with the city manager has approved a recommendation to reduce the fine to a total of $9,250 payable in 30 days, and that is the staff's request of you today.
And I find that to be a reasonable reduction, so I will approve it.
Case number 2025-40, Shannon Halas, owner, location of violation, 705 Grape Avenue, St. Cloud, Florida.
And just so you're aware, there are two cases on this, two lien reduction cases for the same property, so
Did you want to consolidate?
might as well, just so you can have the
Hearing.
whole picture.
Case number 2025-146, Shannon Halas, owner, location of violation, 705 Grape Avenue, St. Cloud, Florida.
Right, so the first case, 2025-4, is basically allowing for unmaintained conditions on the property, broken windows, plumbing issues, electrical hazards, and it was presented to you in March of 2025 with a compliance date of April 18th of 2025 and a fine of $250 a day. That property was finally brought into compliance on May 5th with regard to the accumulation of junk and debris in the outside junk storage, outside the structure, and on October 20th, 25 with regard to the broken windows and maintenance. However, a fine did accrue in the amount of $37,750 for a total of, plus administrative costs of $329.70. I may have read that wrong, but the total amount of the fine is $42,329.77. The city manager entertained an offer on this and then has recommended and requests that the fine be reduced to $4,529.77 payable in 30 days. The other case is similar, however, it had to do with the permitting related to fixing the property, which was never obtained. That fine did accrue to a total of $24,517.77. Again, the city manager has reviewed this and is seeking a reduction in that amount for case number 2025-146 to $2,692.77. So staff would, the city requests your approval of the reduction of both of those fine amounts to the amount stated.
And I do find both reductions are reasonable as stated, and will order them approved as stated in the agreement between city and respondent. In both 2025-4, I approved that reduction of lien, and in 2025-146, I approved that reduction of lien again as set forth in the agreement with the city and the respondent.
Thank you. And that's all we have.
Unfinished business, none. New business, none. Next scheduled meeting, January 21st, 2026.
Anything else from the city?
Nope. Thank you, sir.